Good afternoon, and welcome to the Appellate Division, First Department. Today, we have about 6.5 hours of argument time requested. So as I call the calendar today, please only request the time that you need to make your most salient arguments. I assure you that this bench has read your briefs. We're familiar with the underlying issues of your appeals. There may be some who are here for the first time, and if that's the case, the white light on the lectern will go off when you have 2 minutes left. Or if you've requested less than 2 minutes, it will go on immediately. When the light turns red, that means your time is up. If the panel has further questions past your allotted time, the bench will continue to pose questions, and you will certainly have an opportunity to respond. When I call your case, please rise. Tell us who you represent and how much time that you are requesting. Let me just repeat, the time that you need and not the time that you want. With that said, People v. Brandon Alante. 414. Ronde v. Barnard College.
Andrew Melnick.
525. C. Children submitted. K. v. Merchant Factors Corp. 525. McNeel Samson v. Perez.
Good afternoon, Your Honor. Appellant, 3 minutes and 1 on rebuttal, please. Good afternoon, Your Honor. So respond in 4 minutes, please.
I'm going to give you an extra minute. 4144. All right. People v. Allen Pierre Luis.
Good afternoon. Appellant request 5 and 2.
All right. 523. Vales versus, I'm just going to say W. And please, and this is not to say that I don't want to mess up the name, but I want you to pronounce it for me. I don't want to butcher the name, okay? Thank you. I'm jumping ahead. AM Trust Ventures v. I-80 Group.
I'm calling on behalf of the appellant and request 6.
Uh-huh.
Brian Hale on behalf of the respondent, and I request 5.
All right. 525. Now, Vales v. W, and you're going to tell me how to pronounce that last name. Thank you. How do you pronounce the name, please? Okay. We're going to keep it moving. Thank you. 525. Ochoa v. 3475 3rd Avenue Housing.
Brian Markowitz for appellant, requesting 82.
Uh-huh. Well, there's no one here, so would you like to submit? There's no one here. You don't want to argue against yourself. You'll submit. Thank you. Ping v. Board of Managers of Osmos.
Good afternoon, Your Honor. Daniel Yao for the appellant. We request 4 minute argument, 1 minute.
Okay.
Michael Fishman for the respondent,
414. Thank you. People v. Levi Challenger.
Defendant appellant request 5 and 2.
Your Honor, we request 5.
414. Pittskull, if I'm mispronouncing that, forgive me, you'll correct me, versus Jane Street Hotel.
I'd like to respondent, Arnold Joseph, for the plaintiff respondent, request 5 minutes.
All right. Okay. 4144. HSBC Bank USA v. Donaldson. All right. 4-4. Thank you. 501 Fifth Avenue v. Froley. Okay.
Respondent's 2 minutes. Thank you.
4-1-2. People v. Christopher Collins. Okay, thank you. And Pinskus v. Motulsky, that is submitted. The first case on the calendar, People v. Brandon Alante.
Good afternoon. May it please the court. Emily Barber with the Legal Aid Society on behalf of Mr. Brandon Almonte. Your Honors, Mr. Almonte's consecutive 8-year sentence, which resulted in an aggregate of 11.5 years in prison, was excessive and out of step with this court's decision in People v. Williams. First, the offense here was committed—
People v. Williams is totally different from this case. Totally different. Where, you know, we had the gentleman who, you know, was of an advanced age, a lot of medical issues, certainly was stellar when the person was incarcerated. I don't have to go on, but totally different. We don't have that here.
I'm sorry, Your Honor. I think I may be citing a different People v. Williams. The People v. Williams that I'm referring to was the 18-year-old who committed 2 separate—
That's also different, is it not? There was extraordinary community support. There are a lot of people who interceded on his behalf from where he went to school. You didn't have 2 crimes involving use of a weapon in Williams either. And the point, I think, was also made in Williams, was it not, is that he was a younger person, at least as to some of it, dragged into this by older actors.
Your Honor, that's true. I think the mitigating factors that this court cited in reducing the sentence to an aggregate of 6 years in that case were, as you mentioned, the defendant there had an excellent reputation in his school and community and had overwhelming prospects of rehabilitation. I submit to you that that's certainly true here as well. There were numerous letters in the record of support for Mr. Almonte.
Counsel, he had pled guilty 3 months previously to another gun charge, right?
That's correct.
This is his second gun charge in 3 months.
That's correct. So,
And the minimum, had he been convicted at trial, was 15, right?
so the minimum would have been 5 years. He had the sentencing range 5 to 25. What he took was 8 years.
Right, and the
consecutive-
people were looking for 15. I'm sorry, that's it. The people were looking for 15. The minimum would have been 5. So he got a lot closer to the minimum than the maximum, right?
That's true, Your Honor.
And he resolved not one, he resolved a bunch of different counts, right?
So that's true, and I think what I'd
All
like—
of that's true, right?
Yes, Your Honor.
And yet, and so why didn't the trial court properly exercise its sentencing discretion here?
Your Honor, the sentencing court here could not have adequately considered the really powerful and honestly unique mitigating circumstances here and imposed a sentence of over 11 years. This was a person who was 18 years old at the time that he went in. He, at the time of the offense, had been—
Were those facts known to the trial court?
They were, Your Honor.
Okay, so do you want to talk about facts that might not have been known to the trial court at the time of the plea?
Your Honor, I don't have any new facts on appeal, but I think that this record demonstrates that there was no justification to sentence Mr. Alante for over 5 years longer than the defendant in Williams. Again, this is a person who was...
The minimum is 5. He gets 3 over that, and this is the second offense in 3 months with a gun. And he shoots into a crowd, which luckily did not occur. I think he shot 6 times into the crowd. So 6 people could have died, right? That's a lot different than People versus Williams.
If I may briefly respond, Your Honor.
You can. That'll be the last question.
Yes. Mr. Alante does not wish to minimize his actions here, and on the record, he did repeatedly express that he was ashamed of his conduct here. And I would just point out that he has not evaded responsibility for this. He will be serving a number of years in prison, even if Your Honor is reduced to the minimum on this case. And we would just ask that you...
I have to admire the legal workmanship in trying to use Williams to get a sentence reduction here, but you have an aggravating circumstance here, as Justice Scarpula has pointed out, of you've got, presumably it's 2 different guns in a very short period of time. This is a really aggravating circumstance here, none of which is present in Williams, of course.
And counsel, you can answer that on rebuttal, okay? Thank you.
Thank you.
Good afternoon, Margaret Crookston for the People. To briefly distinguish Williams further, in this case, there was a statutory presumption of consecutive sentences because he committed that second offense while he was released on his own recognizance. So the legislature specifically enacted Penal Law 7025-2-B and tailored it to address.
So the court has to look at mitigation in order, and we would look at the same thing as to whether or not to run the sentences concurrently as opposed to statutorily required consecutive. And your adversary seems to assert that there's a lot of mitigating factors here, his age, things of that nature. Do you want to talk about that?
In terms of to rebut the presumption, the mitigating circumstances would be as to the manner in which the crime was committed or if he had committed it in participation in a group. And neither of those factors was here.
In fact, he was the sole actor here, which might be different from Williams.
Yes, in Williams, it was a group assault in a prison environment, and that's very different here, where a defendant went to the location, like Your Honor noted, shot into a crowded street 6 times.
Although, let me ask you this, really, do you think the trial court adequately took into account that this is an 18-year-old, frankly, boy? Do you think that the trial court took that adequately into account?
Yes, Your Honor, and I think there was, the defendant did submit copious materials, and it was very well known to the parties that he was, all the mitigating circumstances that are raised on appeal. There was a lot of letters of support from the community, and to that point, my colleague here said, he showed a lot of remorse. The record is not very clear where defendant showed remorse. At talking to probation, when he was asked about the offense, he admitted guilt, but when he asked for specifics, he said no comment. When they asked why he had a gun, he said no comment.
So there is this presumption of consecutive time. Did defendant below make an argument to Supreme Court why that presumption should be set aside?
No, that was not raised below at all, and I think that speaks to the fact that there were not the mitigating circumstances identified by the penal law present.
Does that preclude our review of that issue?
No, Your Honor. In the interest of justice, of course, this court is able to reduce the sentence or run them consecutively. However, I think the fact that
we'd still look at the same mitigation, though, right?
Yes, Your Honor. I think the same mitigation factors that were raised below would be what the trial court and this court would look to. And as noted, they were considered, and this was 2 very serious offenses within a short temporal time span, and with everything else noted in our brief, we would ask that you affirm. If there are no questions. Thank you.
Thank you.
So just to address...
You can Yes, please, Justice Friedman's question.
Yes, Your Honor's question. So as to the circumstance here that perhaps was different from Williams, I would say that there were also circumstances. So in Williams, the reoffense, the defendant in that case was incarcerated on his first offense, and he reoffended when he and a group of others recognized someone they believed to be a rival.
Joins a group at Rikers and assaulting
That's
another
right.
inmate. And I don't know that he was the lead on it. I think that was part of the mitigation, was that he was the young defendant being dragged in by older bad actors.
That's right, Your Honor. What is
You
unique
don't
here?
have here. You don't have that here.
But what we do have here, Your Honor, is that
I know you spend a lot of time in terms of mitigation about the fact that he was assaulted by someone in the subway station hours before this crime. Someone threw a scooter at him on the subway station. But I don't really see how, definitely that's most unfortunate, but why does that lead someone to then pick up a gun and shoot at a group of people?
So just to briefly answer, Your Honor, it's certainly not a justification of the choices that followed. It simply puts into context. At that time, Mr. Alante had been doing really well. He had been complying with supervision for 11 months at that point and getting really positive reports. He was working full-time as a lifeguard, and so he got up that morning to go to work, to go to his job, and then experienced this traumatic event. So I just want to place that into perspective for Your Honors and ask that you review the proportionality of the sentence here.
All right, thank you. Rond v. Barnard College.
Your Honor, Andrew Melnick for the appellant, Rosemary
Can
Ron.
you get closer to the mic?
Sorry,
No.
Andrew Melnick for the appellant plaintiff, Rosemary Rondi.
Just pull it down. There we go.
Can you hear me better?
Wonderful.
Okay. Thank you, Your Honors. This appeal presents a narrow but interesting and important question, whether four individuals who engaged in widely disseminated.
Counsel, we know the facts.
You know the facts.
So let's just cut straight to the chase.
Sure.
Please tell us, how do we get around the Martin rule, particularly when the plaintiff did not plead that the entire membership authorized and later ratified the defendant's actions? How do we get around that?
Certainly. We think Martin doesn't apply because
Well,
the
the Court of
defendant-
Appeals says it does. So how do we get around that?
because we never sued the unions. No unions were sued. No union treasury monies were at risk. No defendants other than the four who engaged in the tortious conduct were.
Did you sue these individuals in their official capacity as union members?
We did not sue them in their official
But
capacity.
when you read your complaint, it sounds as if you are suing them in their official capacity.
I understand what you're saying, but we did not. The nomenclature we used was descriptive, provided relevant context, and we sued them as individuals because they engaged in individual, personal, wrongful conduct.
The allegations that some of the allegations include materials distributed that bore the union logo?
That's true.
So how do you separate that?
Simply because people engage in possibly union-related conduct that may have a union title or a union membership doesn't transform individual tortious conduct into immunity. And not all union conduct is protected activity, as the United States Supreme Court
So,
said.
Counsel,
yes.
may I ask you, where was the defamation that you're alleging?
There were at least 4 instances of defamation.
Where, so,
First instance was in a March 7th letter that 2 defendants sent to the president of Barnard College.
okay, on union letterhead.
On union
So
letterhead.
that one, you're saying, of course, you don't send something on union letterhead in your individual capacity. What else? There's something in the
There were-
TWU Express, right, which is a union newsletter.
There was a union
So
newsletter.
what are you pointing to in the complaint that is disconnected from the union?
The personal interviews that two of the defendants gave to the Barnard Bulletin and the Columbia Spectator were in their personal capacities. They
And
had-
not as union members, is that
well,
what you're
they
saying?
were
I
certainly, you
mean,
can't avoid the fact that they were union members.
that's exactly right. So there you go.
But
So
they-
they
but-
are,
but their
that's
actions-
the problem. You've just stated exactly what the
But
issue
not all union activity is protected activity.
Weren't those statements to the newspaper in his union capacity?
They had their titles, but simply because somebody uses their title doesn't transform, as I said, tortious individual conduct into institutional immunity. They are who they are. They're, there's no, we don't dispute the fact that Joseph Rose is president of the local, or that Juan Ramos engaged in malicious, tortious conduct, the aim of which was to destroy the reputation and career of our client. There has got to be a remedy.
Just to go back, because you say that the Martin rule is inapplicable because the union was not named as a co-defendant, right?
Yes.
But you didn't raise that until the reply brief, so this is really unpreserved.
I think we said in our underlying papers that
It's
the
a difference
union
between
had never-
think and knowing. So think is different. Can you point in the record where you actually raised it? Because I didn't
We
see it.
raised it in our responsive memorandum of law that Martin was inappropriately applied. The union was never sued.
Okay. Anything else in the 12 seconds you have left?
Well, we asked this court to do the right thing, to give our client her day in court, and to right a wrong with a remedy.
All right,
And I
thank you.
Thank you very much.
Okay.
If it may please the court, Jade Morrison, on behalf of the respondents.
So why are the individuals protected by Martin?
I'm sorry, Your Honor.
Why are the individual defendants protected by the Martin case?
It's the defendant's respondents' position that they were not sued as individuals. I asked you to look at the actual complaint. I also asked you to look at the petitioner's response to the motion to dismiss at the lower level.
So you're saying that if the complaint were to allege different facts with regards to the individuals, instead of calling them union members and president of the union and supervisor, vice president of the union, that if the complaint were to allege something different, then these individuals could be held in?
I don't think these individuals, but for hypothetically, Your Honor, if the plaintiff had sued the individual officers who actually made the statements as individuals, then that would be different facts, right? Then she could allege that these individual officers who reported to the union in their individual capacity had some animus against her.
I mean, it's kind of like a double-edged sword, right? Because on one, or maybe a shield and a sword, I think is the thing I'm looking for. On the one hand, as a union officer or official, you can basically say what you want, and you have this Martin rule protecting you. But on the other hand, you can basically say what you want and have this Martin rule protecting you. So where do we find that line? Like, is there a line that can be crossed? I do know, and then it's kind of a long question, I do know that the Court of Appeals has, again, looked at this in Palladino, and so how do we get away from that?
So, Your Honor, we're not saying the union officials could just make up something from whole cloth and just run with it. The issue is that these officers have a duty under the NLRA to represent its members, right? If a member complains to the union, they have a legal duty to investigate it, bring it to the employer, and represent their members. If the union officers are now afraid to make statements to the employer or to advocate on behalf of their members, we're in a very bad situation here. In this case, the plaintiff was not exonerated from the facts. There was a full investigation by Barnard College, and they found that the context was very similar. The plaintiff admitted that, yes, there were students coming in with a hijab, and she asked the officers, how do we know that's the same student on the card that's also walking in? So it's clear the officers of the union did not make up this story. And if they did, and there was some prior context and dispute, then that will be different. Here, for example, respondent Samson, but for his name on the letter, there's no prior allegation that Mr.
But they're giving out flyers attacking the plaintiff. There's a union aspect to it, but there's also an individual capacity in doing that. Why should they not be subject to being sued for what they've done in their individual capacity?
Your Honor,
I mean, they're the ones who stood there giving out the flyers.
Actually, to look at the actual flyer itself, the actual flyer itself calls for Barnard to renounce or denounce the petitioner's statement.
And
right?
those
And to
flyers
take-
are on union letterhead, right?
Correct, they are.
Everything they're doing here is on behalf of the union.
Correct.
And the union should be, in your position, I assume, is the union should be able to advocate on behalf of its members.
That is our position.
And there's no allegation here that these individuals would have gone out aside from their union activity, or did go out aside from their union activity and allegedly defame the plaintiff, right? It's
Agreed.
all about what they're doing for their union.
Correct.
And this state has decided that that activity has to be especially protected, right?
That is the respondent's position.
If the flyer didn't contain the union logo, would that be actionable?
The flyer did. On the front,
What if it didn't?
if it did not,
Yes.
I think there would have to be some other outlying facts to show that Mr. Rose, for example, who was not an official, was doing this in his personal capacity and passing out the flyers. Here they were passing out for people entering Barnard's College, which they had an interest in knowing whether or not they would be stopped if they had a hijab on.
Anything else, counsel?
No.
All right, thank you.
Very briefly, Your Honor, this was a narrative made of whole cloth. Our client never said the things that my adversary said.
But when you said your client had no avenue of recourse, she did. She went to Barnard. They did an investigation, right?
Well,
You might not like the...
I'm not going to characterize
Right.
it, but they did some sort of
the fact is, there
investigation.
was an investigation. It's not that they swept it under the table and said, I don't know what you're talking about. She did have recourse.
They did a very poor investigation at no meaningful
And she could
time.
absolutely sue Barnard for whatever she feels was
She's an at-will
unjustified.
employee. She has her rights are so limited with respect to what she can do with.
As are
Mr.
all
Barnard.
at-will employees, right?
I know. Well, thank you very much, Your Honor.
All right.
Your Honors.
Thank you.
Appreciate your time.
KV Merchant Factors Corp.
Good afternoon. May it please the court. My name is Brendan Goodhouse from the law firm Cuddy and Feder. I represent the plaintiff appellant Russell Kay here. So one fact that is not disputed by anybody here is that the director defendants removed Russell from the board of directors via a bylaw that they could not act under. The lower court held that. Everybody concedes that. Now in
So it's the original bylaws that govern.
well, that's what the lower court ended up getting to, but they didn't act under the original bylaws. They don't claim they acted under the original bylaws. What they say is that the amended and restated bylaws, which we think replaced the original bylaws, they say the provision regarding removal of a director was inoperative.
Does it matter whether they acted, which bylaws they
Yes.
acted under, if they gave notice, which sets forth what their claims are?
Yes.
And then the record supports those claims?
The record doesn't support those claims.
Supposing it does.
But the critically no for a few reasons, particularly in this case. So I think it's a blanket no, Your Honor, because under New York law, there is no recognition with board action of this sort of alternative validation doctrine.
That's not correct. Anyone by their bylaws can change what the BCL says or the
No, that's
LLC or the LLC law says
Of course.
about it. So in this case, there is in their bylaws, their first set of bylaws, a provision which permits removal, correct?
That's not what I'm saying.
So then what are you saying?
Alternative, they acted under one set of bylaws. That's what they acted under. They justified the action based on that. They even called out the specific provision in that. And then subsequently in court, actually they didn't even justify it on this, the lower court justified it on these grounds. And the point I'm trying to make, and I want to move to the substance because I think that's where you're getting at, but procedurally, and this is where I think industrial acoustics is pretty relevant to that point, where there was a shareholder vote to pass a resolution to change the number of board members. That was invalidated. It was completely agreed that if the shareholders had made the same vote but identified it as a bylaw amendment, it would have been valid, but they didn't, and so it was struck. Now, it's not apples to apples.
Let's assume that we think that they could have, the original bylaws were in place.
Okay,
because the new
okay,
ones-
let's
go to that.
The substantive point, and this is pretty critical here, is they're fundamentally and substantively different. It's not just like a foot fault where they sent a notice and they cited bylaw 3 instead of bylaw 4.
Under
In
the
the notice-
original bylaws, the directors can be removed for cause, and cause is not defined.
Correct.
Right?
So cause,
If cause is not defined, and then the notice, as my colleague indicates, was sent out, where does that leave you?
the problem is, Judge, cause is universally recognized for removal of a director as something approaching malfeasance, breaches of fiduciary duty. The provision here that the board acted under, this sub B, Romanet 2, sub 3, identifies persistent, inappropriate, abusive, and destructive behavior. That was cited several times in the notice. It was keyed in on that, which is a new definition that was not part of the original bylaws. And what they identified in the notice was being annoying and nagging people to follow up, telling the CEO because he wasn't being responsive, he would have
I think
to be
the
all
issue,
over him.
the issue is whether or not the board had the authority, not whether cause existed. And that's kind of what I'm hearing. So the bottom line is, did the board have authority? That's the issue, not whether cause existed. And if we're looking at Section 3, Article 5, the board had authority.
I don't think the board had authority because those bylaws were replaced by the amended and restated bylaws.
How could they be when shareholder approval was required?
It was not
and there was never, there was not a vote.
Shareholder approval was not required to make those bylaws effective. They were passed as the original bylaws said they could be amended by
So let's say we don't agree with you. Let's say if we don't agree with you on that point, we don't agree with you, just assuming.
Okay.
Right? We don't agree with you.
Fair enough.
So if the board has authority,
Right.
how do we get around that?
If the board has authority, it still matters what they are citing as that authority. If they cite the wrong thing and they act under that, that matters very much because, again, it was substantive and cause. They did not allege a breach of fiduciary duty.
When was the shareholder vote to amend the bylaws? When
It was
did
never a shareholder vote to amend the bylaws.
All right, so let's hear from your colleague.
Good afternoon, Your Honors. May it please the court, Jose Fernandez of Thompson Coburn on behalf of the respondents.
Counsel, is that correct, that there wasn't any vote to amend the bylaws?
There was never a shareholder vote approving the amended bylaws. The board of directors voted to issue the amended bylaws, but that was never approved by the shareholders.
So you agree that the original bylaws were extant at the time that this action was taken?
Yes, Your Honor. I think the record is clear that the board contemplated that these
Right.
amended bylaws would
So
be
let's
voted upon.
right, but it didn't happen. So the
didn't happen.
original, and under the original bylaws, which I think both parties think, the board had the authority to remove, right?
Yes,
For cause.
the board had the authority to remove for cause. That
And
term
cause
is,
was not defined.
and cause is not defined, and it's the
Which
same
is
term.
arguably broader than the amended one, which really defines cause quite narrowly.
That's exactly right. And the case law, we disagree on this point with the plaintiff. The case law does not require some grave dereliction of duty or something like theft or a grave breach of fiduciary duty. The cases say that cause can be any action inimical to the corporate interest. And there are a litany of cases that have upheld the removal of directors based on their, for example, suing the company or starting actions against the company or things like that.
So what actions were alleged by the board to constitute cause?
So I want to take a step back to answer that question, Your Honor. First, cause was never put at issue in the plaintiff's complaint. It is not something that he alleges. He does not claim that, for example, the cause was fictitious or that the allegations against him were completely made up.
Because the complaint only challenges the board's authority to remove him and not whether cause existed to support the removal.
That is exactly right, and that is what the trial court held in reviewing both the complaint and the motion. The trial court expressly held that the first time the cause was raised was in their opposition brief to our motion to dismiss. And so even if the court reached the merits of cause, and it shouldn't because it wasn't pled in the complaint, New York courts do not second-guess board determinations absent allegations of fraud or bad faith, which are absent here. There are no allegations in the complaint that these charges against the plaintiff were concocted for some improper purpose.
And this action that was taken by the board, does it dilute or take away his ability to, as a shareholder, to appoint another director, as all the shareholders have?
No, Your Honor, it does not. And the plaintiff retains the right to appoint a successor director. He has been invited to do that several times and has refused. And so he still retains the right to have representation on the board of directors. He's chosen not to exercise that right. And there's therefore no prejudice in having him removed because he could still be represented on the board. I just want to address one point very briefly, Your Honor, with respect to the fact that the notice of the board of directors cited the provision of the amended bylaws. That's not that's a technical defect that does not render the board's actions ultra vires. The relevant inquiry is whether the board actually had the authority, not whether the notification to the board members cited the wrong provision of the bylaws or the amended bylaws.
And there's no doubt under the original bylaw and the amended bylaw, the board had the authority to do it.
Absolutely, Your Honor.
Okay.
And with that, if the court doesn't have any further questions, I'll cede the rest of my time.
That point that you've just made, that it doesn't matter that the notice has that mistake in it, that's the linchpin to your achieving an affirmance here. Are we agreeing with what you just said?
Well, Your Honor, I think certainly the court has to agree that the board has the authority to remove him, and
that the notice had a mistake in it, that mistake doesn't matter.
That mistake, yes, and that mistake doesn't matter. And the mistake doesn't matter because the BCL doesn't require any particular form of notice. 706 only requires that the shareholders have delegated that authority under the bylaws to the directors. And the cases that the plaintiff has relied upon involve substantive errors where a board acts without a quorum or a board takes some action that actually contradicts the BCL. That's not what's at issue here.
Thank you.
Thank you.
Counsel, how do you get around business judgment rule? How do you get around that?
Every case where the business judgment rule is actually looked at as far as removal, I don't actually believe there is an instance in a for-profit corporation. I think they're all not-for-profits. But nevertheless, in every single case, if you actually read the cases, the court now analyzed it. the court, and we cite this in the brief, the court actually looked at the record. They said it's established this, here's the cause. I think it's,
Counsel, may I ask you, though?
Please.
Your adversary says you didn't even plead lack of cause in your complaint. So let's.
Sure.
Yeah,
Yeah,
I
so-
mean, did you plead lack of cause in your
We
complaint?
pled, we focused, I mean, let's be honest here, and you can
I
read the
just-
complaint.
yeah,
We focused on the fact that the board didn't have authority to act under this.
Okay, so
And-
that,
but
let's assume that we now, we're at the first set of bylaws, which did give them the authority. Did you plead lack of cause?
Because they hadn't, until this concept.
yes or no?
No, so this, yes, the answer is no. That-
You didn't plead it.
But wait.
So we don't even get there unless, because you didn't plead it.
Your Honor, if you look at the whole history here, okay? Notice is sent out under this, under these amended bylaws. The response is you cannot do this. You do not have authority. The board does not have authority to act. The bylaws were in place. It just said for the board to exercise this authority, the shareholders need to approve it. It wasn't that the board needs to, for them to be effective. It was for the board to exercise authority, the
But you
shareholders
could have
need to approve
very easily have said, and if they did have the authority, there was no cost to
it.
it.
Correct. But he could have, but it was directed at the charges faced. Now, and in the complaint it was as well. However, particularly on a dismissal with prejudice, without the chance to replead on an issue that was introduced by the court in its decision, is particularly harsh, considering that if you look at the facts of the complaint, there's absolutely an inference of a lack of cause here. And that's the judge. It's not, did you plead it? It's, are there facts that would allow for that inference? So to not even allow an amendment to challenge this, I think is a particularly harsh result here.
Now, counsel, I'm not sure if you finished answering Justice Pittsburgh's question, because you did have a question. You okay? All right. Thank you. Then we're done. Thank you. McNeel, Samson v. Perez. Justice Scarpula is recused from that case.
Good afternoon, Your Honors. Joshua Annenberg, Appellate Counsel for Plaintiff Appellant McNeel Samson. The lower court erred in granting summary judgment to the defendant San Mateo Construction on the issue of respondeat superior. The evidence raised questions of fact as to whether defendant Perez was within the course of his employment
Counsel,
at the time of the
how
collision.
was he in the course of his employment when, I believe the record showed that he ended work at 8:23 p.m. This accident happened at 2:08 a.m. And then additionally, the items he had in his car were made by him, not even issued by, except for the cones, not even issued by his job.
Judge, the cones is where we go, okay? So on the one hand, I'm gonna split the answer very, very easily. On the one hand, we'll discuss the cones, but on the other hand, we're also gonna discuss the rooftop dome light and the window placard that said that he's a work service vehicle.
But he made those himself, right? Is there any dispute about that?
No dispute.
He said he did that.
But he also testifies that's how he shows that his vehicle and he is working.
But did his job, was there, maybe I missed it, did his job tell him to make them himself?
No, but he said, you know what? I'm a parking coordinator, right? We know the facts. He goes, he takes his cones, his provided job required traffic cones. He sets them out. He saves the parking spots for Con Edison.
Well, then let's talk about control, because how was the employer, how did the employer have control over this individual who left, went to dinner? So tell me, is it that the defendant said, you know what, you have to drive this way, you have to go this way? Explain how they had control over this individual who left 6 hours after, said, I was done with work, I was going to have dinner. After I had dinner, I was on my way home, the accident. So explain to me in that, where is the element of control?
The element of control, because we come to that from the Lundberg case of the Court of Appeals. And an employee acts in the scope of his employment when he's doing something first in furtherance of the duties he owes to his employer.
And what was that? Particularly since he said the shift ended at, well,
Those,
I'm almost done.
Yes, I'm sorry.
No need to apologize. The timesheets indicate 8:27, done. He testifies, I'm done. So explain to me, where does the control come in?
the control in the cones, C and C. These are job mandated cones.
Counsel, if we accept your position, that means that anyone at any time when they are driving with something that they use at work and they get into an accident, their employer is now somehow going to be involved in that.
Judge, respectfully, I think you went too broad.
I went too far? I've read your papers.
Judge, respectfully.
And we know what respectfully means, so let's not use that term. Let's, just answer the question.
I'm sorry, Your Honor, but the control aspect is derived from Lundberg, where it even says the words indirectly. I'm going to go back to the cones, and then I want to shift for a moment. But with respect to the cones, he has got to bring them home. If he's got to bring them to the job, and these are mandated, he's got to bring them back home, because he can't leave them there. They don't give him new cones. They're not disposable. He's got to take the cones from his house. He keeps them in his car. He goes to the job site. When he's done, he's got to bring it back home with him for the next job site. And then I want to shift.
Thank you. You said 4, I gave you 5. Okay, I gave you 5, so we're going to now
Appreciate it,
hear
Your
from
Honor.
you.
Thank you.
And you'll get 5.
I appreciate that, Your Honor. Thank you. Good afternoon, Your Honors. May it please the court, Matthew Corcoran for the defendant, San Mateo Construction. Your Honor,
So, counsel, I just want to pick up on the thread that he just made, and maybe you can address this. These cones in the car, that seems to be a big point. And now he's been given these cones by his job. He has to bring them to the job site, take them home from the job site. They're not going to some office somewhere. Why doesn't that impose respondeat superior for his employer?
because the existence of work material in the car is not enough in and of itself. The employee is still required to be going to or from the job site directly without any kind of personal venture in the interim. As you pointed out, Your Honor, if we put any case where there's a personal item, or excuse me, a work-related item in a car, we're essentially telling an employer they're now an insurer of their employees' vehicles, for lack of a better way of explaining that. So we have the cases—
Well, to prevent that, then maybe employers should not have people carry work items in their personal vehicle.
And I think that that would place an onerous burden on both employers and employees for having to transport themselves first to a job site, then to the office, and or back again, depending on when they go to work. I think it's a beneficial relationship to both employees and employers to allow the employee to carry materials that they may need to a job site rather than have to report in, report out. I think that would create unnecessary legal frameworks. But we have the exception here already when the employee is carrying work-related materials, and we can, if you, for you know, just to all encompass everything, we can talk about the cones and the placards and the lights, which you are correct, Your Honor. The employee said he provided and put there himself. The presence of work material in a vehicle does not automatically put the vehicle in the scope of employment. We cite Matos versus Michelle De Palma on page 13 of our brief. The employee in that case was driving to work with materials they intended to deliver to their employer when he was involved in an accident. The court found that he was not within the scope of employment despite that, because he took an alternate route to go on a personal errand on the way into the office. And we have that same situation here. Frankly, I'd argue it wouldn't matter if this accident happened 20 minutes after Perez clocked out of his shift or 6 hours, as it did happen here. The minute he took a personal venture to go get himself dinner, he severed the connection and was no longer in any scope of employment. There's a part of the reply brief that appellant submitted that says we concede that the presence of the cones mean that he was presumed to be in the scope of employment. I would say that I don't agree with that. If you look at page 14 of our brief, what we do say is that he would be considered to be within the scope because of the cones were he driving directly to or from work? I just want it very clear that the court is aware we do not concede that point if you review the reply papers. But also let's talk about this 6-hour time gap. Like Your Honor said, Perez clocked out at 8:23 p.m. on April 28th, 2017. This accident happens at 2:08 a.m. on April 29th, 2017. And another point appellant makes is that because my client, the employer, is unable to account for what their off-duty employee was doing in that 6-hour time period, there is somehow a burden on my client to either be liable for him or offer more evidence because there is a question of fact as to my employer's liability. I think that also would set a very invasive standard if employees are not only able to, but required to inquire about their off-duty employees' whereabouts and activities. I don't think anybody wants that to happen. And in fact, the current framework that we have, Labor Law 201D, says employers can't be prejudiced or punish employees because of their off-duty activities. And we do have legislation pending before the court, which we cited in our brief, that actually limits an employer's ability to monitor their off-duty employees, even using tracking devices for employer-provided vehicles. I think there's just absolutely no question. Perez was not in the scope of employment, and the court was correct in their decision. Thank you, Your Honors.
Thank you, Your Honors. With respect to rebuttal, I would like to say that in this instance, all the court needs to do is to identify questions of fact. As the appellant and we were the plaintiff.
So, counsel,
Yes.
speaking about the questions of fact, isn't it a fact that Mr. Perez owned the vehicle?
I'm sorry, he owned.
That he owned the vehicle?
He owned the vehicle.
So isn't it a fact also that he ended his shift at approximately 8:23 p.m.?
Your Honor, I don't think that's an established fact because it goes to the question.
Well, that's the timesheet that you have.
That's
his
correct.
schedule.
But if I,
Isn't it a fact that
that's
he
what
said?
the fact is that's what the timesheet said and what he
Counsel,
testified.
I'm speaking, please.
I'm
Just
sorry.
let me finish the question.
Yes.
Isn't it a fact that after he ended his shift, he testified under oath that he went to dinner?
For
Isn't that a
15
fact?
minutes, and then he couldn't figure out what he did for the next 6 hours.
And isn't it a fact that at the time of the accident, he was on his way home?
That's what he
So
testified.
now you tell me, where is the issue of fact?
Why
The
is
court- Where's the issue of fact that requires that this matter be sent to a jury?
Why is he having on his car his roof dome light and his window placard?
Wasn't that all explained that this was something that he did on his own? Those were not provided by his employer.
Respectfully,
Well, that's his testimony
that's
under
his
oath.
testimony, but
So what do you have to contradict that?
It indicates.
Counsel,
I'm sorry.
what do you have to contradict that?
What do I have to contradict?
Yes.
It's an issue of his credibility. It's an issue if he says he's not working.
What does the
then
court
why
have?
does he need to have
Counsel.
the dome light and
Counsel.
the window placard
Counsel.
in his window?
Counsel, when I'm speaking, please, just,
Your Honor, I'm sorry, but you seem not to be accepting my
no, I'm not upset, because you are going contrary to
We're
the
not gonna,
facts.
whoa, we're not gonna characterize anything that a justice says on the bench. So I'll tell you what. You have 10 seconds to finish your answer, and then I'm calling the next case. Go on.
Thank you, Your Honor.
Okay. People v. Allen, Pierre, Luis.
Good afternoon, and may it please the court. I'm Brandon Miller of the Legal Aid Society on behalf of Appellate, Mr. Pierre Lewis. In the moments before the offense, Mr. Pierre Lewis, a man with severe mental illness, thought he heard the voice of a woman calling for his help. At that time, he temporarily lost touch with reality. Because of the substantial mitigation here, and because of who Mr. Pierre Lewis is, as a brother, as a father, and as a son, the 6 years imposed here was excessive.
Now, counsel, you know, it's just so unfortunate about the defendant's history, of, the mental health struggles. But didn't the sentencing court take that into consideration when imposing the sentence?
Your Honor, these factors were before the lower court, but of course that doesn't impede this court's ability to review them anew at this point. But I think an important way to understand the question that's before the court here today is to ask whether the lower court's consideration, how that consideration measures up against the guidance that this court provided in the case People versus Sparks and cases like it, which Sparks was decided after the sentence was imposed here. And so the mitigation in this case all essentially does tie back to Mr. Pierre Lewis's severe mental illness. As we discussed in our brief, the story essentially kicks off when he was 16 and his older brother committed suicide after killing his own 3 children. This was a deeply traumatic incident, an event in Mr. Pierre Lewis's life that seems to have been what catalyzed the development of his own mental illness and mental health struggles.
Counsel, was your client on medication at the time of the offense?
There's indication in the record, in particularly the PSI, discussing Mr. Pierre Lewis receiving treatment at some point previously in Connecticut and New York for schizophrenia. I think it's possible that because his symptoms had not previously manifested in an incident of this magnitude, Mr. Pierre Lewis hadn't.
His compliance with taking his medication has been spotty, hasn't it? Didn't Dr. Dimitri characterize his compliance at someplace between 20 and 60%?
That's in the 730 report, Your Honor. I think that we can't place too much stock in the medication compliance history that respondent highlights because of the particular circumstances that exist at this point in the stage of life that Mr. Pierre Lewis has reached at this point. By the time he's released, he will have experienced multiple years of incarceration and self-reflection and have a deeper understanding of the severity of his mental illness, the degree of his need for help, and the stakes and gravity of complying with treatment. And he'll also—
Did your client waive his right to appeal?
There's a waiver of the right to appeal here that's invalid for multiple reasons, beginning with the lower court's failure to accurately inform Mr. Pierre Lewis about the scope of the appeal waiver. The court's language represented the appeal waiver as an absolute bar to appellate relief and failed to clarify what remained.
Well, no, it says you don't give up constitutional rights that survive these types of waivers because you can't waiver them. So he didn't make it an absolute. That's not what the record says.
Well, Your Honor—
So what else? Other than that, are there other issues that you have with the appeal waiver?
There's that issue. There's also the issue of the failure to properly distinguish the automatically forfeited trial rights from the rights that Mr. Pierre Lewis was being asked to voluntarily waive as part of the agreement.
So the court said, you've discussed with your attorney a separate condition, which is you waiving your right to appeal. You've discussed that with your attorney, correct? And the defendant says, yes. And do you understand what giving up after having spoken to your attorney, you understand, don't you, what the giving up your right of appeals? And then it goes through some things that are waived and some things that aren't, correct?
Your Honor, there's significant ambiguity in the explanation that was provided.
And then he signed a written waiver, right?
The written waiver—
And he spoke to his lawyer before he signed the written waiver, and he didn't have any questions, right? And are you agreeing to waive your right to take an appeal after discussing this with your attorney and after my having explained it to you? And he says, yes, right? He's not a teenager, right?
He's someone with unique vulnerabilities because of
I'm
his—
just asking, he's an adult. He was found fit to proceed. He said he spoke about with his attorney about the appeal waiver. He understood what the court was saying, and he agreed to waive his right, right?
Can I respond to that, Your Honor?
Please respond to that.
Again, I want to put the entire context of the colloquy into context of Mr. Pierre Lewis's underlying mental illness, which persisted as a concern even after the finding of mental of capacity to proceed, which flows into the merits in this case.
Thank you.
Thank you.
Good afternoon, Your Honor. It's Joseph Tucker for respondent.
Counsel, let's assume that we find the waiver to be invalid. Let's start from there. Why isn't this case warranting the treatment of People v. Sparks, where we have this long storied history of mental illness?
I think the distinction between this and Sparks is laid out in the brief. In Sparks, you have someone who was diagnosed with 14 psychotic disorders. He spent all but 2 months of his life in prison, 3.5 years in solitary confinement. He was in prison, he was engaged in multiple altercations, and he tried to commit suicide several times. He was treated by or examined by a psychologist, a forensic psychologist, for 6 hours with a record of 3,600 pages, who produced a detailed 25-page report. Here, there's absolutely no psychiatric documentation to support the claims that counsel is making here. The only documentation we have is from 2 psychiatrists who examined him during the 7:30 examination, which we don't even know how long it lasted. It was a video examination of him, and everything that they have came from his own words. Now, I won't deny that his life is tragic and what happened to him with his brother and everything is tragic.
The victim's mother was upset with this sentence, wasn't she? She felt that the amount of time imposed was inadequate.
She said that the son, who had his ear bitten off by this
He was
defendant,
severely affected, that his life has fallen apart from this, and therefore she put in a statement rather than him, I think is what must have happened. And she was upset that the sentence wasn't sufficient.
she was, and her son was. The victim was also, Your Honor. And they
So,
spoke
I
to the
mean,
court.
counsel, you have to admit, right, biting someone's ear off clearly manifests that the person may have I won't say clearly, but it's fair to assume that that person has mental health issues.
Well, yes, except for the fact there's no documentation to that effect, and there's his admission that the
So we
day
don't know
before he
what
drank
it
a bottle
is
of
and how
liquor.
severe it is, and whether he was just really super angry that day or what.
Well, he also smoked crystal meth. He smoked 2 grams of crystal meth and drank a bottle of liquor. I mean, that could lead anyone.
And
He had a history of drug and alcohol abuse, right?
A long history of polysubstance abuse, yes. Hallucinogens, crystal meth, PCP, Molly. I mean, he experimented with
And he
everything.
had been put on medications in the past, but he didn't really, whether or not he complied with taking his medications was spotty.
After his arrest in this case, he was released from Rikers. He had 3 other pending cases, 2 of them involving physical altercations and assault. And admittedly, his social worker informed the DA that he went back to drinking alcohol and smoking crystal meth. He has a history of noncompliance with psychiatric medication when he's given it to him, both while he's incarcerated and when he's in the community. I think that he got a fair deal here. He could have been...
Originally, he was going to get more time.
He would have received 25 years for the top count. It was reduced to
But even
7 years.
the original plea was for more time.
Right, it was 7 years. It was reduced another year to 6 years. 6 years and 5 years of post-release supervision is not too excessive, Your Honor. And if there's no further questions, I'll rely on my brief. Thank you.
Thank you.
So, counsel, what reduction are you seeking?
We believe that reducing Mr. Pierre Lewis's sentence by 18 months is appropriate and in line with other similar cases. But a reduction as low as 1 year would be a meaningful step towards improving Mr. Pierre Lewis's mental health outcomes.
Well, why do you think that? Why do you think that if he's not incarcerated for a year, that he will start taking medications, get off the drugs and the alcohol? Why? What is in the record that would lead us to believe that?
Your Honor, this court's insights in People v. Sparks speaks to how prison is inherently unstable, destabilizing, and detrimental to a person's mental
But he's unstable when he's outside because he's taking all these drugs. Actually, he told one of the people that examined him, one of the doctors, that he had consumed a bottle of liquor just before he committed this offense. So how is it that reducing his sentence by 1 year is gonna prevent him from continuing to use these substances?
Your Honor, again, because prison is inherently detrimental to his mental health, any further time.
But he was outside when he was out. He was not in jail when he was drinking alcohol and doing drugs, which led, according to him hearing voices and attacking this person.
Again, Your Honor, I think this all comes back to his mental illness, which prison is an inappropriate environment to treat. The substance abuse that you're referring to is addressed in the PPI. The social worker's analysis concludes that his substance abuse is rooted in and inextricable from his mental illness. And so,
But while he was out on this case, while it was pending, he committed another assault. Isn't that so?
Please.
there was a subsequent conviction for a misdemeanor. I think that further substantiates the fact that Mr. Pierre Lewis was experiencing a moment of unprecedented crisis in his life, and the sentence that his conduct warranted should have appropriately accounted for this crisis, this mental illness, and 6 years does not do that.
Thank you.
Thank you.
AMF Trust Ventures, VI 80 Group.
Good afternoon, Your Honors. Tom Cawley on behalf of the appellants. Plaintiffs are not members of the LLC, and therefore, under Delaware law, they are precluded from maintaining derivative claims on behalf of the LLCs. Plaintiffs were redeemed as members of the LLCs in May of 2022, long before they sought to amend their complaint to add derivative claims.
How do we look at plaintiff's position that the reason that they were redeemed is to prevent such action as what's happening right now?
Right. Well, first of all, the Delaware continuous ownership rule, which is they refer to as the bedrock of Delaware law, requires that you be a member of the LLC or the corporation, or the shareholder of the corporation if a corporation is involved, throughout the time of the litigation, starting when the complaint is filed and you file derivative claims until the time that the case is resolved. So that is a bedrock rule, and the courts have held it doesn't matter how you lost your status as a shareholder or a member.
Well, counsel, can we address how the fraud exception applies to the continuous ownership doctrine?
There's two exceptions. One is the merger exception, which does not apply. There's a second exception, the fraud exception. But the Delaware courts are very clear on what that means. It means that the action that caused the plaintiff to lose derivative status, either a member or a shareholder, was to deprive them of derivative status. And that's not the case here. This case has been going on for 3 years.
Now, it's the sole purpose,
It's a sole, well, no, or I think they use the sole or dominant purpose.
Okay.
Some say sole, some say dominant. But there's absolutely no evidence in this case that the plaintiffs lost their LLC membership because there was a fear that they would bring derivative claims. That just was, there's no evidence of that. And again, this is not...
What this case is about, one of the main issues in the case is whether the plaintiff should have lost being a member, right?
Right.
So you say he can't bring a derivative action because he's no longer a member.
Right.
Suppose, let's just assume at the end, he prevails that he shouldn't have lost his membership. What is his remedy then?
Well, they've got direct claims. The direct claims are based upon that they say that they lost their membership inappropriately. So they have direct claims. So they have direct claims which say we lost.
Will those direct claims make him good for what the derivative claims may have been? Well,
the derivative claims, obviously, he would be suing on behalf of an entity, right? And what the Delaware courts say, you can only sue on behalf of an entity if you're a member of that entity. To the extent that they have direct claims and they were wrongfully terminated, then this court has addressed that and said that's a fact issue which will be decided, that is something that they can prevail on direct claims, get money damages for. But they cannot bring derivative claims on behalf of an entity in which they are not a member. This is a bedrock principle of Delaware law. And the reason for that is, the policy reason for that is that the Delaware court says that the interests of the plaintiffs have to be aligned at all times with the membership of the organizations. They have to be members of the organization. And if they even at a point in time do not become members, then they lose their status to bring derivative claims. It's a bedrock principle. And it cannot be retroactively, see how it determines on the merits if they were wrongfully deprived.
When do you look at standing at the beginning of the
Exactly,
case, not at
exactly.
the end
It's a
of the
threshold
case,
issue. It's a
right?
jurisdictional
So
issue.
if you don't have it to start, it doesn't matter if later on something else happens, right?
Correct.
I'm so glad you brought that up, that standing is a jurisdictional issue, because it seems to me that you're trying to create this third exception, right? That
Exactly.
we should look at the merits to see, if, the expulsion was, without authority, but how do we even get to that if, we can't talk about standing, which is jurisdictional?
And this court has said that. The court said it has to be something you determine at the beginning. It can't be based on the outcome of the case, because you never know at the time you litigated whether you had standing. We'll figure it out someday. Thank you.
Thank you.
Good afternoon. I'm Brian Hale from Mount Atkins on behalf of the plaintiff AMF in the case.
So since you no longer have this membership, and since standing is a initial decision which has to be made, what basis is there for you to assert a derivative action?
Well, let's take a step back and talk about that's not an undisputed fact, and I think that's one of the places where the ship is passing in the night here. This purported redemption of our interest, there's no doubt we bought the membership interest, no doubt we participated as members. And then in May of 2022, we get a notice that says you're now hereby redeemed. Now, the question is, that's pursuant to a contractual authority under the LLC agreement that the parties entered into. And I think New York law is clear, and Delaware law is clear, that when a manager attempts to exercise a power beyond the scope of the LLC agreement,
the manager has.
That is void.
Let me stop.
Okay.
Right? The manager has the authority to remove you. It says it in the LLC.
In his reasonable discretion if various conditions
Yeah,
are met.
but that's a breach. That's not ultra-virus. Ultra-virus is, I have no authority ever to do it, because otherwise every breach would be ultra-virus. So it can't be that.
That's not the case in the context
I think
of
it is
an
the
LLC
case.
agreement.
I think it absolutely is the case. So let's assume that's not, let's move on from that. Where is it, under Delaware law, you have, you have to be a member. You're not, right? You have your direct claims.
I don't think that's the correct interpretation of the exercise of a power. And I posit this hypothetical. If my plaintiffs and my clients had sent him a letter that said, oh, by the way, we're terminating you as a manager, and here's your redemption, we've redeemed you. That's not a breach of the agreement. That's
I agree.
That's a lack of corporate power.
Your client didn't have the power under the LLC agreement.
And his client didn't have the power. His client didn't have the power to redeem us either.
Let me just finish.
Sure.
His client had the power, you just don't like the way he exercised it. That's exactly what the agreement says. So again, let's assume that you and I are not going to agree on that. But let me ask you this. If you are not a member, how can you bring a derivative claim?
Well, then there's two different ways to evaluate that. I think that the exercise of the alleged exercise of the power is void ab initio, and it never happened. I think that's the construction. But moving beyond that.
Assuming that we don't agree on that.
Moving beyond that, then we bring the claim and the direct claim. The damage is
you have your direct claim, so
we have a direct claim, and so long as the damages are aligned up, that's one of the things that Delaware law makes clear, which is why you have these exceptions. Which is in those cases, there is part of your appraisal remedy when you're involuntarily redeemed as a stockholder in a corporation, pursuant to a Delaware thing, is part of your remedy is the value of your derivative claim. So the derivative claim would be litigated as part of the value of your claim, your direct claim, the improper redemption, the improper thing.
Again, but I'm saying,
how do we get to the derivative claim? How do we get to the derivative claim? Well, there are exceptions to the rule. Right?
How do you fall within those exceptions? Because my understanding, there's only two.
Well, let's take a step back as to what happened in this case. Is LLCs are different because there are claims that could arise under contract and there are claims that could arise derivatively. And in this case, it's clear we were terminated in order to eliminate litigation claims, period. That's alleged. Plaintiff, defendant admits it. They sent us a check, then they try and claim that the check, it was a handwritten check, and that was some sort of settlement and release of the agreement. They said that you're going to sue us. So we know that
you're saying that the fraud exception applies?
The litigation exception, in Delaware, it's all kind of smushed together because it's in the context of these involuntary mergers for stock cases,
right?
Which is usually what happens is the corporation does some bad faith machinations to deprive someone from standing.
Well, let's go
that's
back.
exactly what happened in this case on the LLC redemption.
Let's go back because the complaint and I'm just going to paraphrase, you know, that the defendants, you know, prevented the plaintiffs from bringing derivative claims by serving up a pretextual withdrawal notice designed to deprive plaintiffs of the derivative standing. That same allegation was in a prior complaint that the court found insufficient, and this court upheld that.
That's a different complaint, Your Honor. That was for
I know.
It was for a different plaintiff.
Oh, I know. But I'm just saying, it's the same allegation.
Your Honor, I think that the complaint from my client, AMF, is different than the original complaint that was
Oh, I
passed
understand.
upon in Hemingway.
Oh,
And we have,
listen.
and
Oh, I
specifically in our case, they said.
But I am talking, and you're talking over me.
I apologize, Your Honor.
Okay. So, but I'm going to go to another question, because this, you know, to decide the merits, how do you even decide the merits? How can there be a third exception when standing is jurisdictional? How do we even get to that?
I think you have to look at the allegations of the complaint, which, if true, do they provide the standing? This has never been decided in any decision in any reported jurisdiction about an involuntary redemption pursuant to contractual right in an LLC.
Okay.
New York law, to Zolas, is clear that the continuous ownership rule applies for voluntary redemptions.
All right.
That's the case they cite. Maldonado is a voluntary sale.
And my colleague, Justice Burke, has a question for you.
And I'm glad that you ended on case law, because I just wanted to know, I know that you cite 2 Delaware cases since we're applying
Right.
that. I think it's Ropco and Donato. Neither one of those involve former members of LLCs. Do you have any case law that stands for the proposition of what you're trying to assert?
Quite frankly, Your Honor, I think we've made this argument from the very beginning that this fact pattern of an involuntary redemption in an LLC to deprive someone of standing hasn't really occurred. And, you know, I think the closest is something like Shapiro, where there's been transfers of stock which allegedly happened. That's a New York case that we cite, where there's transfers of stock, and usually they require some sort of consent. You know, the shareholder agreement has to sign off, the company has to sign off, and then there's a transfer, and the question is that transfer effective? And if it is effective, then the plaintiff no longer has standing. And I think that the New York cases we cite specifically say that, you know, where it's contrary to a shareholder agreement, that transfer is void, therefore plaintiffs have such standing. The cases we cite in Delaware, Your Honor, I don't think there are any. We cite 2 cases. As I recall, it's Zohar, and I think the other one was Campus I, but I could be wrong. Those are cases where corporate machinations happen to deprive a manager or someone of standing. And then the question that the Delaware court confronts is that person still a shareholder? Is that person still a manager? And the Delaware courts look at the powers that are exercised, the LLC agreement, and they find that if the corporate machinations and the elimination and the removal of the manager of the shareholders was contrary to the LLC agreement, that is void. It's not just a breach. Those Delaware cases specifically say those corporate actions are void. That's how we end up here. This is not about the merits. It's about whether or not we allege that. They can bring a summary judgment action and say that all these different things. Otherwise, you basically, the rule is not a manager can redeem and foreclose out derivative claims by redeeming members. And there are differences between breach of contract and fiduciary duty claims and derivative claims. For example, attorney's fees.
And that's where we're going to end now, and we're going to hear from your colleague.
So the Delaware courts haven't made any distinction between corporations and LLC. They apply the same law to both. And the Delaware statute says, the 2 Delaware statutes, one says that the plaintiff has the burden of showing derivative status in his complaint. And yet there's another Delaware statute that says that an LLC, to bring a derivative claim on behalf of an LLC, you have to show that you're a member of the LLC at the time you filed the complaint. So those are Delaware statutes.
Let me ask you one question about, so I think what your adversary is saying is I can plead around that by claiming that this is an ultra vires act. But we both agree, or I think you and I would agree, that the LLC agreement gives the manager the authority to do it, and the claim here is that the manager abused that authority.
Correct.
right?
This was
Not a case where there's no authority.
It's section 3.8 of the agreement. In fact, this issue was before this court. And the argument was the court determined that that's a fact issue and remanded it after summary judgment had been entered against my client. It says a fact issue. And this court has used the term, I think it was in another case, I don't have the site in front of me. There's a difference between no power, which gives rise to an ultra vires act, and the misuse of power, which is what they're alleging here. Misuse of power leads to damages for breach of contract. It's not void ab initio. It's not possibly void ab initio. There's a statute that says my client had the right to, Mr. Hawani had the right to redeem them if he, in his discretion.
What do you say to counsel's argument that my damages aren't going to be as good because I can't sue derivatively?
I don't know what to say to that. He has direct claims. I mean, this is a Delaware statute.
They are what they are, right?
Yeah, they are what they are, and Delaware has determined this as a matter of policy. This is what you have to do to bring.
Doesn't have pain and suffering damages either, right?
Right, but if you want to bring a claim on behalf of somebody else, you've got to be a member. That's the setup that Delaware has said they have to follow. Thank you.
Thank you. Vallis v. W.
May it please the court, Allison Sanders on behalf of Appellant Providence Rest. It's our position, Your Honors, that the lower court erred in holding that Providence Rest failed to establish prima facie entitlement to summary judgment in this matter. Our expert, Dr. Diamond, demonstrated that the employees of Providence Rest did not deviate from the standard of care in the treatment of the decedent, Mrs. Vales, while she...
Assuming that we agree that Providence Rest met their burden, plaintiff's expert's affidavit raises an issue of fact.
Well, it's our position that plaintiff's expert did not address Providence Rest at all. There's no reference at all to Dr. Diamond. There's no reference to any opinion that Dr. Diamond had. And there's also no reference in plaintiff's papers as to Providence Rest at all. It's only...
Wasn't there reference that a certain medication should have been ceased?
Correct. So
at Providence, when the patient was at Providence Rest?
Correct. So plaintiff's expert talks about ceasing the use of lisinopril when they talked about Jacoby Hospital. When it turns to Providence Rest, plaintiff's expert only talks about lisinopril as it addresses co-defendant Dr. John, who has been dismissed from this case. Now, it's our position as well is that the court erred in finding that they misapprehended the fact that the plaintiff's counsel addressed Providence Rest expert when in fact...
So counsel, is the expert specifically saying that Dr. John made a mistake, or is the expert saying that having administered lisinopril when the plaintiff is undergoing this severe episode because his potassium level has been increased, that was a departure?
Well, it's our position that plaintiff's counsel only addresses that in terms of Dr. John, not to any of the other employees of Providence Rest. The only argument that they set forth against Providence...
Dr. John wasn't on duty in the days that matter.
Correct.
Whether it's one day it morphs into a second day or just 2 days. And so it was being done by the physician's assistant employed by Providence. So why isn't there an issue of fact? Because it's plaintiff's theory of the case that based upon what Jacoby said upon discharge, the lisinopril should have been discontinued when those potassium levels were going up. I understand it's the defendant's point, it's your point of view that there could have been more harm in doing that than benefit, but doesn't that create a stark issue of fact?
Well, the issue with that position is that those discharge instructions happened 13 days before, and the discharge instructions actually say, run the lab values the next day, January 18th. The lab values were run January 18th. The potassium levels were normal. They were run 6 more times while she was admitted to
But then
Providence
it goes
Rest.
up. But then it
It goes up, and on the day of the death, her potassium levels stabilized, which demonstrated that the administration of the Kyonex, due to those elevated levels of potassium, were working. In fact, they went from 6.3,
But I mean, you
they
have
went to
an
6.0,
expert
and then
that's saying something
4.7.
else, right? That's your position, sure, absolutely. And you'd say, assuming that you make out your prima facie. But then another expert says, but you should not have been administering this. And look, I mean, we're not fact finders up here. So why is that not create an issue of fact?
Well, plaintiff's expert actually says that when a patient is hyperkalemic, the providers need to assess the patient's overall health. And the overall
Are
health...
you disputing that the plaintiff's expert says that your facility should not have been giving the patient that drug at the same time?
I am disputing that, yes. So
Okay, so I guess you're reading the expert's report in a way that I'll have to ask the plaintiff whether...
Well, it's our position that the expert actually doesn't address our expert report at all. It's completely silent, so any claims as to Providence Rest have been deemed abandoned.
I just want to follow up on something, because I was under the impression that the plaintiff's expert also, opined that, if Providence had any staffing issues, if Dr. John was unable to, monitor the potassium levels, that the decedent should have been transferred back to Jacoby. Wasn't that also in the,
That was also alleged, and they were alleging that the decedent was deteriorating during her time there, but there's no evidence of deterioration. She had no complaints, she had no shortness of breath, she was not tachycardic. Even that morning, she was able to go and do her, I was gonna say her PT and OT.
Because the thing is this, you say, oh yes, we administered the medication, the levels went down, but we just kind of gloss over the fact that about like an hour or 2 hours later, unresponsive, and unfortunately, passes away. But that's kind of silent. We don't talk about that.
Well, she also had a DNR, so we have no idea what
she went to therapy, but then she couldn't handle it. She had to come back.
Well, it said that she was having anxiety, and she went back, and she had actually spoken to Dr. John that morning, who said that she was in good health and fine and good spirits. She went down to physical therapy. She came back and became unresponsive. She was DNR, and there's no autopsy. There's absolutely no cause.
Let's hear from your colleague. Let's see what.
Thank you, Your Honors.
Good afternoon.
Robert for the plaintiff. I think that
So your colleague says that the potassium levels had stabilized.
No.
On the day before death, what was the potassium level?
it had gone down. That's not the issue. The issue is that it was dangerously rising, and they have made an accusation or an assertion that had it stabilized to some degree, that was enough because of the other drug to say, oh, we're okay. I want the bench to just understand, I need 1 minute to say, this is a situation where we're asking for our question of fact to be resolved. The question of fact was first argued that our expert was not an expert. And the court determined
Let me ask you about counsel's statement that your expert only talks about Dr. John. And
not true.
Okay, so that's what I'm saying. What does he say about anyone other than Dr. John?
That the people at Providence Rest during
Providence Rest?
This is a Maduba situation. She's under the care of the personnel at Providence Rest who are duty-bound to monitor these things. Whether Dr. John...
Doesn't the physician's assistant give a Keonex the day before death, and probably on the day of death it was also prescribed? And it's your position that the Linsapril should have been discontinued, besides giving the Keonex.
And I suffer from old age and doing this for too long to say, that's our question of fact. If a jury said, well, they did enough, my day is over. We haven't had an opportunity to do this. This motion was brought on by them, initiated.
Right.
We have been deprived of our question of fact.
So let me ask you again. It's your position that your expert did not focus solely on Dr. John. That could
It's summarized in pages 10 through 13 of our brief with respect to the assessment of what's going on in light, and counsel has respectfully indicated we didn't address Dr.
So then
Hyman.
how do you?
We
how
did
do
by
you-
showing
one second,
our
Counsel.
contra coup numbers.
1 second. How do you explain that the failure to stop lisinopril, I guess, or lisinopril, is under the heading, Dr. Anima John departed from the standard of care by administrating contraindicated medications. That seems to say that you're only saying that Dr. John didn't do it.
That's something to be interpreted. Dr. John was dismissed out of this case for other reasons having to do with the
Whether he was there that day, but the question is,
Right.
does that heading lead one to believe that that claim only goes as to Dr. John?
I don't believe it leads to believe that at all. I
just
think
wanna
that
go back to something that you-
we have to produce that going forward. Remember, we're still under 3101D where we haven't disclosed the name of
I
our.
want to go back to something that you said. I want to make sure I heard you correctly, that you were challenging the defendant's expert, the qualifications.
No, they challenged ours. That was the first issue, is whether our expert was qualified.
Okay.
The court said, yes, he is. He or she is. Once that's done, the next level was whatever my expert said didn't disclose a deviation and proximate cause.
Just wanted to make, okay.
And then they go on, and I'm going to say.
No, I misheard, so
I
it's fine.
understand. And the last thing I wanted to say is, she brought it up here, is that there is no autopsy. Well, I think that the court has to recognize that's a fallacy. If there's no autopsy, there's never a wrongful death case. We know that's not true. We have the time to develop what the cause is, and in fact, our expert said it's his belief that the manner in which the movement of lisinopril, the numbers of the hyperkalemia were going, that lisinopril should have been discontinued, and in fact, that was the directive from Jacoby. So go to find it in this case.
Okay.
Thank you. I'll yield back my time.
And you know, counsel, don't say old, say seasoned, veteran. Sounds better, right? Seasoned, veteran.
I just
Okay.
want to focus on the fact that plaintiff's counsel is only talking about one lab value over the course of a 13-day period of treatment. And that lab value then decreased upon the administration of Kinex. It was done on two separate
Am I
occasions.
correct? The lab values initially started okay, but then it shoots up.
Correct. And this decedent had a very long medical history. She had a medical history of already high potassium.
But didn't Jacoby say, said in its records that you sent to you, don't give her that if you are giving her other medication?
Specifically says the following day. It doesn't say 13 days.
Okay,
I think we
well-
can all agree that over the course of a 13-day period of time, that a patient's treatment can change.
Right,
So
but-
her levels had been stable throughout those 13 days. So to then go back 13 days prior and to use those same discharge instructions could also be problematic, you know? That
Sure, but don't you see isn't this like a classic? One expert says one thing, one expert says another?
Sure, but that expert didn't say anything about Providence Rest. That expert said it all about Dr. John, who
Well,
was
Dr.
dismissed
John is.
because the court misapprehended the fact that their plaintiff did not address Providence Rest at all. They addressed Dr. John, not Providence Rest, and that's why Dr. John was dismissed from the case.
Dr. John has no relation to Providence Rest?
Dr. John was employed by Team Health, and Team Health then sent the doctors over to
Inside the expert opinion, it says underneath the heading that my colleague read, it does begin with, as it relates to Providence, when a nursing home, and it goes on.
And then it focuses just to Dr. John. In terms of with Providence Rest, it just talks about what the proper care and treatment should be at a nursing home. And then it goes into Dr. John and Dr. John's
I understand the issue that
treatment
you're
of-
raising about, but you wouldn't contend that the nursing home isn't liable for the physician's assistant.
Well, the physician assistant takes,
The physician's assistant was your employee.
correct. But there's no argument about that. The argument is about Dr. John, who
I
is no longer
understand.
in the case.
All right, thank you.
Thank you, Your Honor.
King v. Board of Managers of Osmos.
I wanted to come back.
Good afternoon, Your Honors. My name is Daniel Yao for the appellant. This matter should have been discontinued at the Supreme Court level. There was no special circumstances.
Should it have been discontinued with prejudice?
Without prejudice, Your
Without
Honor.
prejudice?
Without prejudice, Your Honor, because there was no special circumstances. My colleague is going to argue that the voluminous discovery process or the hiccups that the parties experience makes it very special. But
There had been certain times when your client hadn't complied with discovery orders.
I'm sorry, Your Honor, can you repeat the question?
There had been certain times when your client had not complied with discovery orders, particularly the July 24th, 2025 order.
I believe my client had made a good faith effort to comply with the order.
But you sought an extension for discovery, and the court denied that as well, right?
That is correct, Judge. And I would submit that these type
And so then you go on to your client wants to discontinue the action without prejudice, even though a lot of discovery had been turned over already, and without prejudice, because you were unable to continue to pay attorney fees. Was that not the reason?
that was one of the reasons that my client stated in his affidavit.
Let's talk about the July 2025 status conference order, because that order set forth a August 29th, 2025 note of issue date, and that was marked final, right?
That was,
It's either final or it's not, so it's final.
that is right, Your Honor. So it would have had,
Oh, I'm gonna move on, okay. And then your client sought to discontinue without prejudice only after being unsuccessful to extend that discovery deadline, right?
correct.
Okay. Now, you said that there was another reason besides being unable to pay counsel?
I believe that the ability to pay was one of the chief reasons that Mr. Penn.
What was the other reasons?
The other reasons would be, it could be he didn't want to continue anymore.
Well, if he didn't want to continue anymore, why without prejudice?
That is because, Judge, in all type, I think my client has candidly stated in his affidavit, if he had the money, if he had the resource of the world, every litigant probably wanted to try it again, and he acknowledged that fact. But we submit that it's unfair for a litigant to be have this case discontinued with prejudice and not having the ability to come back. God forbid he wanted to give it a try.
So what weight should we put on the fact that, you know, no money, but now you get money, you hire new counsel, you have counsel for this appeal. So how does that factor in?
Judge, I would say that this is New York State and this is the city of New York. A lot of things happen. The person might have wanted to reconsider his position, and in his affidavit, I believe he said he wanted to better or manage his. He wanted to better allocate his resources. It could be 2 years from now, a year from now, I don't know. I do not want to speculate into what my client was thinking.
Is it reasonable to say to the defendant, you've gone through all of this, there have been discovery proceedings, they've litigated it, for you to come back and say, I'm stopping, and, tomorrow I can just start all over again, and you're back to square one, and you have to go out and expend legal fees to defend, et cetera. I mean, how would that sort of an approach?
So, Judge, I know my light is up.
You can answer that.
I'll just answer very briefly. So it is not unusual in these type of cases that discovery goes a year or two. In this case, only 13 months elapsed from the date of answer to the date of we made that motion. And in case laws, there are mentioning that it's part of the cost of ordinary lawsuit. Thank you, Judge.
Thank you.
Good afternoon, Michael Fishman, on behalf of the respondents, defendants.
So, counsel, is it part of the course of an ordinary lawsuit to have to do it all over again if this matter is dismissed without prejudice and then the plaintiff decides to bring the action again?
No, and I don't even think that's the heart of this issue, because I think Justice Bannon looked at this and she didn't act arbitrarily. She had every reason to infer that what the plaintiffs were doing was trying to avoid the court's order. Counsel says that his client ran out of money, and that's what his affidavit says in October when he came back to argue that that he should be allowed to withdraw the case without prejudice. But what Justice Bannon pointed out is that just merely a few months earlier, when trying to get the court to extend the deadlines, to extend the date for the note of issue, didn't come in and say, I have no money. And no, in fact, said, I need to keep going. I need to get my day in court. When the court said, okay, the deadline is firm, the plaintiff then turns around and says, well, no, I really can't go forward. So it's really a strategic attempt to avoid the consequences of Justice Bannon's deadlines, and then to turn around and say, well, you know, I filed this case in May of 2024. I made all these various strategic motions. I tried to get books and records. That was denied. I tried to get an attachment order. That was denied. I filed a notice of pendency. We had to litigate that. That was denied. All of these things, and the one thing they didn't do was engage in discovery.
You're right. So defendant produced documents, responded to 3 motions?
3 motions. We produced documents. In fact, the record shows that we produced 2,500 pages before discovery requests were ultimately served, another couple of thousand after that, when the defendant's counsel, with plaintiff's counsel, and ever
Expended
opened
a
the
lot of
link.
money. Defendants expended a lot of money on this
Money,
so far.
time, effort.
And as things stand, if they would try to start again, your answer would be res judicata.
If it was allowed to be denied without prejudice, then we would be having to do this whole game.
And if not, they can't, because you would just say, well, this has been decided.
But I mean, no court should allow a litigant to avoid the consequences of a court order by simply withdrawing the case and starting again. It's like the NBN case that they cite. I mean, in that case, they were looking for a better forum to apply New York law, where instead of South Dakota law. So they withdrew the case after the judge had
It
said,
can't be, if you don't like the way things are going, you just stop and say, well, I'll start over tomorrow.
right, exactly, and I'll find another judge who may not be so difficult about deadlines, or will listen to me when I want to just keep going. This case started in May 2024. Judge set a deadline for August 2025. The plaintiff didn't even show up for his deposition, respond to notices of deficiencies in his own discovery requests. So when the court said in July, I'm giving you to the end of next month, show up for your deposition, start doing something. Instead, he filed an application saying that he needed more time because he needed to get his day in court. They filed a notice of appeal on the denial of that application, but then allowed the time to pass in order to perfect that. So here, this is a rather effective strategic path, right? You just withdraw the case. And none of things that I don't have to suffer the consequences of my own inaction, or I don't have to suffer the consequences of what the judge has put in place. I don't have to worry about those orders, because I'm going to do this all over again. And that is a special circumstance, in my opinion. That is what should be avoided, and that's exactly what the court said. The court looked at this and reached a conclusion that this was a strategic method to avoid the consequences of the order. Thank you.
Thank you. Perhaps you want to start off and respond to what he just said.
Sure. So, Your Honors, I believe volume does not speak for itself. My colleague is trying to say that because they engaged my client in discovery process, because they produced a lot of records, I believe I have addressed this in my brief, volume does not equal to quantity. I'm sorry, volume or quantity does not equal to quality.
Well, did your client even show up for his own deposition?
I believe that there's some dispute to that. So in the footnote of my
Well,
brief,
I mean, either the deposition took place or it didn't. Did it?
I believe there was some discussion of deposition. My client would say that he
Did your
didn't get
client
notified.
produce any documents?
I think my client did produce documents.
Oh, because my understanding was he hadn't produced a number of
I believe my colleagues disputes that my client's production wasn't sufficient,
Right.
not that he never produced anything.
Right. So why wait until after 4 motions and discovery not showing up at your deposition to make that motion?
And I have addressed this in my brief, Your Honor. I believe if I had a case, I wasn't that lawyer, but I wasn't it was handled by my
Right,
predecessor.
obviously,
If
right.
I've done, I probably would have done something different.
Right, okay.
I
Thank
thank this
you.
court.
People v. Challenger.
Good afternoon. My name is John Palmer, appearing on behalf of Levi Challenger. Mr. Challenger pleaded guilty in exchange for a satisfied sentence. The state's 47-day delay in releasing Mr. Challenger left that sentence promise unfulfilled.
But why isn't that something that could be handled by a civil remedy? Why is vacating his plea warranted when the court specifically indicated that that was something that they couldn't promise, right? Isn't that what happened here?
Well, Your Honor, the court did not say that it could not.
Said I cannot make that representation.
Could not make that representation regarding the prosecution's record about how Mr. Challenger's post-release supervision would start to run in relation with his maximum expiration date or the current date. But as far as the possibility of the civil remedy here, Your Honor, there are 2 distinct harms here. First is the overdetention itself, which of course Mr. Challenger could and perhaps should seek a civil remedy for. But there's also the fact that Mr. Challenger did not get the benefit of his plea bargain, and the Court of Appeals has said
Was the
that
court able to promise that the defendant wouldn't serve more than 5 years? Was the court in a position to make such a promise?
Well, Your Honor, the court promised and imposed a sentence that Mr. Challenger had completed.
The court said that you would get credit for the time that's served, right? That's what happens at a plea. You'll get credit for whatever time that's served. The calculation is then done by someone other than the court. And then it is what it is. Why did I guess this might be outside of the record. His lawyer did not come back and say, hey, my client's still in jail, or still in prison, rather, like, what's going on?
Well, Your Honor, the defense need not state that it does not consent to someone being held well beyond the period that the
court is
parties
not in a-
reasonably expect.
The court is not in a position, or do you say that it is, to know how much time the defendant has been incarcerated? The court imposes a sentence, and then it's corrections which sees and makes that determination. And if the defendant is in disagreement with that, maybe there's an Article 78, maybe there's a writ that needs to be brought, but this is not something that judges typically do, is it?
No, Your Honor, and we're not saying that Judge Farber here did anything wrong at the time of the plea and sentence proceeding. But to determine whether this sentence fulfilled Mr. Challenger's plea bargain, we must look at the reasonable understanding and expectations of the parties at the time of the guilty plea to determine whether the sentence imposed comports with the plea agreement.
So counsel, the promise was 5 years jail, 5 years post-release supervision.
Correct, Your Honor.
And the court stated at the time of the plea that Mr. Challenger would get credit for whatever time he had served on that case.
Correct, Your Honor.
And the court sentenced Mr. Challenger to 5 years jail and 5 years post-release supervision, and stated in the record that he should get credit for all the time he has served on the case.
Correct, Your Honor. And
So what is the promise that the court made that the court did not fulfill?
it's not that the court did not fulfill the promise.
But that would be the basis for the withdrawal of the plea, right? Because that's your argument, that the court did not fulfill a promise that
Mr. Challenger was promised a 5-year sentence.
He got
He
one.
had already completed. And anybody based on the record that Your Honor just stated would expect that they would be released promptly where the parties
That's,
waived
that's,
the pre-sentence.
that's not within the power of the court. The court can sentence him, and then, as has been already stated, the Department of Corrections will do the computation.
Well, Your Honor, what the court could have done is when determining this 44010 motion, the court could have granted it, as Mr. Challenger did not receive the sentence that he was promised, and his promise was left unfulfilled.
Thank you. We'll hear from the people.
Good afternoon, Your Honors. May it please the court. Andrew Kim for the people. The record in this case plainly shows that there was no unfulfilled promise made by the court. As Your Honor has mentioned, the promise here was that
And what's the defendant's remedy? Because he clearly was incarcerated for more than 5 years. Is it an Article 78 proceeding or a civil proceeding?
Yes, Your Honor, the remedy here would be to pursue a civil claim
Right.
against the city, the state, DOC, DOCCS, or the people
The
responsible.
47 days, right? The extra
Exactly, for
47
the
days.
people responsible handling his case post-sentence.
So he does have a remedy.
Absolutely, Your Honor. It's just that the remedy here, and we appreciate the significance of his claims. We're not trying to be dismissive about the 47 days. It's just that the proper remedy is not to reverse his conviction. The court did what it was supposed to do, sentenced him to the promised sentence of 5 years prison and 5 years post-release supervision. There were no additional promises made, nothing about an exact release date or an approximate one.
Right. In fact, the court declined, absolutely said, I can't make any more promises about how many days you've been in or haven't been in, right?
I mean, it's not as if the sentence was supposed to be 5 years on the commitment sheet. There was 6 years, and then he's kept in longer. That's longer than the promise of the 5 years what he was supposed to get. That's not what we're dealing with here, right?
Right, Your Honor.
He was promised 5 years. The court gave him 5 years. Corrections did the calculation, maybe not as expeditiously as they should have.
Exactly, Your Honor. And again, this was a guilty plea that was knowingly and voluntarily entered. There's no basis in the record that there was any additional promises made. And I think I'll just add that these sorts of plea deals are very favorable to the defendant. They're beneficial, practically speaking, because
The court could have directed that he be released at the time of sentence.
No, Your Honor, because that would mean that the court would be sentencing him to time served, which would have been an illegal sentence. Because the defendant was being sentenced to a period of state prison, followed by post-release supervision, the defendant did have to go through DOCCS
But
custody.
even when there's a sentence of time served, there's still some kind of out processing. It's not
Yes, Your Honor.
walk out the courtroom.
That's correct, Your Honor. If the defendant had been incarcerated or pending his case, he would still be returned to DOC or DOCCS custody. And so if there are no further questions, we ask that you affirm. Thank you.
Thank you.
Just 3 quick points, Your Honors. So first, as far as whether Mr. Challenger needed to remain in DOC's custody or go to DOC's custody for his calculation, the criminal procedure law actually prohibits commitment where someone has been resentenced and the new term of imprisonment is less than or equal to the vacated sentence. So no, DOCs should not have continued to detain Mr. Challenger under these circumstances.
Okay, and
Further-
again, that's docs, not the court, right?
But it's not a matter of simply what the uniform sentence of commitment says, what the court says regarding the length of the sentence. It is the reasonable expectation and understanding of the parties, and 47 days is well beyond what anyone in that courtroom expected to happen in this case. And further, Mr. Challenger gave up his right to trial in exchange for his liberty. And it is clear from this record that everyone in the courtroom expected him to be released soon, and the state did not uphold its end of the bargain, whether it was the DOC, whether it was DOCS, whether it was the court or the prosecution.
No, you can't just rattle them off and say whether it was this, or that, because everyone here has very specific duties. And for us to say that we're going to vacate it, there had to be some error made by the court. And the court promised 5 years, sentenced him to 5 years. That was the understanding. If there was some problem with the calculation, that's a different problem.
There does not need to be an error by the court, Your Honors. There's cases where someone is promised a certain sentence in relation to another, and that other sentence is modified, and there's no error by the court, but the person's promise has not been fulfilled. And Mr. Challenger here, under these circumstances, has the right to hold the prosecution to its proof, and we ask the court to reverse the conviction and remand for further proceedings.
Thank you. Pitzel v. Jane Street Hotel, if I'm mispronouncing that, my apologies, and you will correct me.
Good afternoon, Your Honors. Jessica Bove from Perry, Van Etten, Reynes, and Kuttner on behalf of defendant appellant, Ackman Security. Your Honors, we are seeking reversal of the court below's decision denying Ackman's summary judgment motion on the grounds that the inaction of its security guard to stop or prevent the patrons from dancing on the ballroom furniture basically would trigger liability
So, counsel,
under the
the
Espinel.
security company has a contract with the hotel, right? Not with the plaintiff.
Yes,
So
that is
normally there would be no duty, right?
Yes, that's.
And so then we look at Espinal.
Yes, that's
So
correct.
what is your view about the Espinal exceptions?
Okay, well, based on the court's decision below, the court basically found that liability could be imposed under the exception of launching an instrument of harm.
And why do you disagree with that?
Because the court is basing that on the inaction of the security guard. Our position is the inaction is there's a difference between malfeasance and nonfeasance, and a lot of the court
a lot of cases. A lot of cases say failing to do more is not launching an instrument of.
That's correct. In fact, there are cases where even if an individual had a contractual duty in order to prove liability, it would have to be an active action, an affirmative action, meaning it had to be malfeasance as opposed to nonfeasance. The court relied on two opinions for its decision, Solomon and Cornell, and in those cases, even though the court is citing them, how they're different is in those cases you see that there was some sort of affirmative action. In Solomon, the maintenance company put some air blower next to a wet condition, and it caused it to become exacerbated for the plaintiffs to slip.
I want to turn your attention to the other aspect of this appeal, which is that there's an indemnification claim against you. And regardless of whether or not you're liable to the plaintiff on this, why aren't you under contractual indemnification? Because under your contract with Jane, you've got a broad indemnification provision stating arising out of or in connection with Acumen's work. And isn't this something which, again, regardless of what your obligations to plaintiff may be, it arises from your work?
It does not arise from the work. If you look at the contract between Ackman and the Jane Hotel, you'll see the scope of work. The scope of work does not include stopping patrons from dancing on the furniture. In addition to that, Ackman was required to abide by the Jane's stand guidelines and protocols for their bar and ballroom. In that document, there's no indication that Ackman had an obligation to stop patrons from dancing on the ballroom.
The term secure assets and property for the hotel's ballroom include the actions that happened here?
No, in my opinion, no. This is an incident where parties are dancing on furniture. The furniture flips over and falls on the plaintiff. based on the testimony, there was no obligation. No one ever told Ackman that it was their responsibility to stop patrons from dancing on the furniture. Even the director of the Jane Hotel testified that no one gave them that instruction. The Ackman security guards were supposed to follow the instructions and the guidelines from the Jane Hotel.
Thank you.
Okay, let me start with the contractual duty. If you look at page 420.
Represent.
I'm sorry.
Yeah.
Arnold DeJoseph, it's late, I'm getting old. Arnold DeJoseph, seasoned, I heard that.
Veteran or experienced.
And Judge, by the way, you're pronouncing the name exactly correct.
Oh, wonderful.
Okay. So Arnold DeJoseph for the plaintiff respondent. First of all, if you turn to page 422 of the record, you'll see the A, B, and C, the duties in the contract. Security personnel perform their duties in an efficient, conscientious manner according to the client's requirements and procedures. Security personnel shall be courteous, helpful to the customers and community. Security personnel shall
But
respond.
Mr. Joseph, your client isn't a party to that contract. She does not get the benefits of it unless there's an Espinal exception. Let's head to that.
Yes.
Okay, so let's head to the Espinal exception. So in this particular case, the claim is, but factually, that's not what Acumen is doing at this hotel. When it came to chasing someone down off a fireplace, they undertook that duty to do that. Okay, so I would put to you that this is a very subjective thing that's going on as to what their duty is and when are they supposed to interact with the.
You have no duty with respect to your client. It's very straightforward. You know that and I know that. And Espinal says only 3 situations would they, because then anytime you had a contract, you'd have unlimited amount of people. So let's deal with the Espinal.
Yeah, I mean, tell us how they launched a force of instrument of harm.
They launched an instrument of harm by selectively following what rules they were supposed to enforce at the club. And by not enforcing the rules they were supposed to enforce, they allowed an instrument of harm to be launched, or they stood there and watched it and didn't do anything about it. And this brings us to the point where...
So Mr. DeJoseph, if the security person there would have said to the people dancing on the furniture, get off the furniture, would that have been enough?
It might have been if they got off.
Well, what if they didn't?
Well, if
what
they didn't, then their job, if you look at their contract, their job, and according to the Jane Hotel, this idea that they weren't supposed to get the people off the furniture is not what it was not what Ms. Guerin testified to in her EBT.
Well, she testified to the fact that she's seen people dancing on furniture and never done anything about it.
She testified that no dancing was allowed on the furniture.
Right.
Page 270.
But she has seen people dancing on the furniture and never said anything.
Judge, everybody has seen people dancing on the furniture.
You know, but that's the thing. So now we go to, again, her testimony where she says that the security company was supposed to handle guests with care, not be aggressive, be polite, be firm, but don't put your hands on guests. So how were they going to get the people off the furniture?
Well, we'll never know because they never tried anything.
Well, the thing is, that's the thing. Because if all they can do is say, get off the furniture, and they don't listen, then what's the next step? And they're not allowed to do.
And I understand this, but I also think the court is just neglecting one fact. That security contract, beneficiaries of that contract were the customers that came into this hotel. Wasn't with them, but they're the customers. If you look at every security
that is just not the law. That is not right. You know
I mean, that's the same thing as saying that the beneficiaries of a snow removal contract are the people walking on the sidewalk. And we already know, based on Espinal, where that leads.
I agree with the court, except in this case, it is clear that this is a defined group of people. It's not expanding the contract to include all these people. It's expanding. The people are mentioned in the contract. You are going to make sure it's safe for the client. And that's what she says. So whether or not the instrument of harm, we'll debate. But
Thank you.
Good afternoon, and may it please the court. Joseph Thompson from Ryan and Conlon on behalf of the defendants, respondents. First of all, I think the court had multiple grounds for denying Acumen's motion for summary judgment. We've talked a little bit about beneficiaries to the contract. The court did cite to the case Kuti versus Sarah Security Services, which
No, but in that case, there was a specific promise made. That's a different thing. There's no, I mean, it's black letter law that you're not a third-party beneficiary under a tort theory for something going wrong like this, unless you can prove an Espinal exception. That's the law. We all know it. You can fudge whatever you want, but it is what it is. So let's deal with what exception is applicable here and why.
well, that case that was cited by the trial court also.
Again, I'm going to ask you this again. What Espinal exception are you looking at?
Right.
And
so
why does it apply?
That specific case also cited, mentioned detrimental reliance, which I don't think is applicable here, but it also mentioned displacing the duties to
So
keep.
you're saying that this security company completely displaced Jane Street?
For the hours of 12 a.m. to 3 a.m. on a weekend night when
Did anyone even argue that?
It was argued that they entirely displaced the Jane's duties.
They were expelling someone. Didn't they have to clear it with Jane?
There may have been testimony about that. There was also.
I thought Ms. Guerin said that she was in charge of the ballroom and what was going on inside there.
Sure, but with regard to security in the ballroom, Acumen had upwards of 15 security guards in place.
That doesn't, but you have to show total displacement. So there was no evidence of total displacement. So let's put that one aside. The next one is if there was a special duty alleged, with the plaintiff said she never talked to any of the security guards. So the only one that could possibly apply is launching the instrument of harm, right?
Sure, and Acumen's own witness contradicted our the Jane's witness's testimony. The Jane testified that dancing on furniture was not allowed because it was unsafe. Acumen's witness testified that it was encouraged. So you have an Acumen security guard.
Launch an instrument of harm. Again, you have to launch. Launch means you're doing something. What did they do that
Based on the proximity of the security guard to these 6 to 8 men dancing on the couch next to plaintiff, and the fact that their own
But
boss
that's a
from Acumen.
refusal to do anything, right? Or not do, if in fact they had to do anything. Because I wanted to get to the indemnification next.
Sure.
But if they had to do anything, they refused to do it. They didn't, it's not like they threw someone on the couch and then the couch fell on someone else, right? That maybe would be a little bit more on the nose.
The witness for Acumen stated it's what they wanted. So, the proximity to the activity, the time that passed while the activity was going on. I mean, if it were, for instance, a fight that was ongoing for 30 minutes and security was standing there and said it was encouraged, I mean, I think that would be a similar circumstance that would constitute launching an instrument of harm.
Let me ask you a question about the indemnification, because the contract says that they're there for perimeter access and control, identification procedures, and to secure assets and property. Perform their duties in efficient, conscientious manner according to the client's requirements and procedures, be courteous, and it goes on. No one alerted them to tell them to stop, tell them at that moment to tell people to stop dancing on the furniture. And how do you read their duties to you inside this contract as it states in terms of letting people dance on the furniture when your own website encouraged it?
Now, the light is off, but you can answer that question. That's going to be the last question. Then we're going to hear from the
Without regard with the website, which I think is inadmissible hearsay, but in this contract, it says the client's requirements and procedures. And in the Kuti case, it says you're allowed to look outside the parameters of the four corners of the contract if there's any ambiguities. And the trial court cited that case. They cited it for a reason. They looked outside of the four corners of the contract and looked at the testimony of Mr. Sheldon from Acumen and Ms. Garone from the Jane, and they used their testimony to determine what those quote-unquote requirements and procedures were. And according to Ms. Garone, Acumen was supposed to stop unsafe behavior, and that would include standing on furniture or dancing on furniture.
Thank you.
Thank you.
Just quickly, I'll address the plaintiff's arguments concerning beneficiary. It obviously doesn't apply. I'll direct your attention to Pagan versus Hampton Houses. In that case, the plaintiff's decedent was murdered in her apartment, and the court found that that the landlord's, the security had no duty to protect the plaintiff under the contract.
How do you deal with counsel's argument that you're standing next to the couch without removing the patrons is equal to launching an instrument of harm?
I disagree because in that instance, there's no action. There's no affirmative action taken. There's no action in terms of trying to intervene. I would compare it to the case where the plaintiff cited in their brief, Kavanaugh. In that case, the security guard went and spoke to patrons to tell them to stop smoking, and afterwards, the other patrons assaulted the plaintiff. And there, the court said, well, the security guard took an action, but it didn't go far enough. Here, everyone is saying they didn't do anything. So if it's they didn't do anything, all these cases that they're citing do not really apply. And with regards to Kuthi, you'll see if you compare the contract of the Ackman's contract versus the Kuthi contract, you'll see that they're not the same. In that case, they're claiming displacement of duty. The contract was for 24 hours. Here, we had a contract for security for only 3 hours. With regards to the indemnification, there's nowhere in the contract where it discusses telling patrons to get off the furniture. And the guidelines provided by the Jane is that they need to take direction from a Jane manager. Even in terms of allowing someone entry, they have to go by what the door person said, and the door person was an individual that was hired by the Jane Hotel.
Thank you, counsel.
Okay.
We have all the arguments. Thank you. HSBC Bank USA v. Donaldson.
Good afternoon,
I'm
Your
just going to
Honor.
wait for him to, get settled. Okay. Okay, you may begin.
Robert Griswold, Log Siegel Group, on behalf of the appellant, HSBC Bank USA. Your Honor, in this case, this loan...
How do you get out of FAPA?
So, Your Honor, I don't think that FAPA is really dispositive here. We have a case where the loan in the prior foreclosure was not actually accelerated. I still think that you need to make a factual determination that the prior foreclosure action actually accelerated the loan. Otherwise, the mere accusation that you had an acceleration in a prior mortgage, in a prior foreclosure prior to the commencement of the case, in and of itself, if FAPA precludes us from even forcing the defendant to make a factual proof that this loan was validly accelerated under the terms of the note and mortgage.
Why was the previous action dismissed? Wasn't it because of lack of personal jurisdiction?
Yes, I believe that's the case, and that speaks to the failure to properly serve that 2009 foreclosure action. Your Honor, the note and mortgage itself, pursuant to sections 9 and 22 of that loan document, set forth the means by which a loan is accelerated. Here, it wasn't done. The defendant has not shown proof that 30-day letter, which was required pursuant to the terms of the mortgage, that 30-day letter was sent. And if you look at that case in front of the Second Department, Gruen, Gruen, 237 AD 996, that case really speaks to an almost identical factual issue. That's a case.
But FAPA says that a plaintiff, meaning you, shall be stopped from asserting that the instrument was not validly accelerated unless the prior action was dismissed based on an expressed judicial determination that the instrument was not validly accelerated, right?
Yes, and so
That's pretty straightforward. Was the prior action dismissed based on an expressed judicial determination that the instrument was not validly accelerated?
no, Your Honor.
So
But
then you may not assert, this is what FAPA says, you may not assert that the instrument was not validly accelerated. I didn't make up this law. It is what
Your
it
Honor,
is.
there's a balancing test here. There's the debtor needs sorry, I apologize.
I'm not sure FAPA allows for this balancing.
It is what, that's the law.
You need a basic factual determination that the loan was
That's
accelerated.
not what the law says. The law says the only way you are stopped from claiming that a loan that went bad in 2006, and you've tried now twice, this is maybe the third time, to foreclose on it, wasn't validly accelerated. Isn't this exactly what FAPA is trying to prevent? You from trying in 2025 to go back for a loan that you're saying was defaulted in 2006.
So, Your Honor, first I would note that this was
2007.
this
maybe,
action was commenced in 2018, so we're not trying in 2025.
Okay, so
But
yes,
if
if you're telling me 15 years is so much better than 20 years, I don't know if that
Your
goes
Honor,
that way.
the point is simply that you need to have a basic assertion that the loan is accelerated.
The
Pursuant to the
statute says what it says, and can we agree that according to the statute, you are stopped from arguing that the loan wasn't validly. If you don't like the statute, you can challenge it on grounds, but that's what the statute says.
Your Honor, we do have argument about the validity of FAPA and about whether or not it should be applied in this case. I will rest on my papers entirely on that. My point here is, let's say you had a case where there had been no prior foreclosure action, and a defendant makes the assertion that the loan was previously accelerated. They still need to make that basic factual determination that they are correct. If you look at the terms of the note and mortgage, it requires several
Isn't that different
things.
because you don't have a judicial determination, and here you do?
I apologize, I don't understand.
You're taking an analogy which is not similar to what we have here.
But my point is that
In the case you were starting to present to us, you might have a good point, but that's not this case.
well, yes, but I think that
Anyhow,
if
your
you look
time
at
is up, but
Groom-
has any payment been made on this mortgage since December of 2007?
No, Your Honor.
Thank you.
Good afternoon, Your Honors. Michael Kennedy Carlson for respondent Katie and
That's very
Donaldson.
fortunate that FAPA was enacted for your client, right?
Yeah, I'm happy that it was enacted for him, and he's quite happy with it, too. If I might just deal with counsel's, I wasn't expecting his hypothetical situation. The estoppel argument that Your Honor spoke of earlier, the just specific statutory language, it stops them from claiming that a prior action was not a valid acceleration. So if there was no prior action, as his hypothetical said, then the estoppel wouldn't apply. So that nightmare scenario of somebody just making up something, that's not.
So let's talk about the constitutionality of your client not having to pay back its loan because of FAFA. How is that constitutional?
Well, first of all, I mean, the courts have ruled on the
Well,
Constitution.
let me just ask you. It's undisputed your client didn't pay back the loan, right?
Correct.
Hasn't paid anything, lived since 2007 in a home without paying back the mortgage, right?
Correct.
So how is that constitutional?
Well, for one, the plaintiff is stopped and forbidden from raising that because they haven't served as the New York State Attorney General. And according to the executive law, you can't challenge the constitutionality of a New York State statute without serving the Attorney General.
Right, but we could authorize, we could just say, serve the Attorney General. So where does your argument go from there?
I mean, since they didn't serve the Attorney General, I didn't pay it. I didn't work on that as much as otherwise if they had. But there are other cases out there where the banks have served the Attorney General, and sometimes the Attorney General gets involved, sometimes they don't. but the constitutionality of FAPA has generally been upheld throughout the courts of this state. The other thing is, let's look back at the fact that their first case was dismissed because someone failed to appear at a Travers hearing. Presumably, whoever law firm that is has some liability coverage. Presumably, there's already been conversations with the liability carrier for whoever was covering.
And I guess just the flip side of the not having paid a mortgage for 20 years, I mean, there's this flip side of that argument that, you know, lenders shouldn't be allowed to start action, stop them, start them, stop them, right? That's what FAPA is there to prevent.
Yes. Yes, and also there could potentially be tax consequences if they lose this. They could hit him with a 1099-C. That may or may not have tax consequences for him. I'm not a tax advisor, so I don't deal with that. They didn't have the law of the case on their side in the beginning as their brief claims. The June 21st, 2019 order just said that factual issues remain and actually called the order that was before that erroneous. So although it didn't have language saying I vacate the order, when the judge says my previous order was erroneous, you know, that's not something that they can rely upon for law of the case. And then I've heard so many things spoken about FAPA over the course of the last several years, but I've never heard anyone claim that it's not a change in the law. So I don't know, until I read this brief, but unless Your Honors have any other questions?
Thank you.
Thank you.
501 Fifth Avenue v. Froley. I did not grant your request for a reply brief. I didn't grant that request.
Oh, so I don't get an opportunity to respond?
That's an error.
No, I had withheld 2 minutes. Oh.
I did not grant the request to file a late reply brief. Thank you. 501 Fifth Avenue v. Froley.
Good afternoon, Your Honors. Nicole Meyer from Bora Goldstein for the plaintiff appellant. The court below here erred in finding ambiguity in the purchase agreement, which clearly set forth that contracts used in an operating tenant's business were to be included in the purchase, and specifically enumerated those assets which were excluded from the sale, which did not include the lease. Alternatively, if the court agrees that the contract is ambiguous, the court below erred in resolving that ambiguity on a summary judgment motion.
So let's just assume that it's ambiguous. Let's just assume, right?
Mm-hmm.
And you have the deposition testimony of Mr. Ali.
Mm-hmm.
What, if any, evidence did you submit to raise an issue of fact, to refute, his testimony?
Well, first of all, our client was not a party to the purchase agreement, so the drafter of the purchase agreement, Mr. Froley, the individual, defaulted here. There's a judgment against him, and his intentions with respect to drafting are not part of the record. But Mr. Ali's...
I'm saying, but you opposed the summary judgment motion, right?
It was plaintiff's summary judgment motion.
Forgive me, you know what, it's late, so forgive me.
No, understood. And our argument was that based on, the reading of all of the provisions as a whole, the purchase agreement is unambiguous and provides for the purchase and assignment of the lease to the respondents. Because the agreement is unambiguous.
Wait. Where does it say that your client that the new owner would purchase the lease in the agreement? Read it to me.
So you have to read the different...
No, just read what I want you to read to me, where it unambiguously says, and I purchased the lease.
It does not mention...
Yeah, so it doesn't say that at all. Not even close, right?
Right, but if you look
where do you think, what language are you saying is unambiguous that it actually purchased the lease?
So the paragraph 1 provides for the purchase and sale of all assets of the business, including contract rights. And if you look at paragraph 14B, It provides for that rent is to be prorated to the date of closing.
And in fact, that would suggest that there wasn't a purchase of the lease. There'd be no reason to do that, right?
No, I don't agree. I read that to mean that tenant remains liable for rents up until the date of closing. Purchaser then becomes liable for rents after the date of closing, and that's reinforced by paragraph 14G, which provides for...
Wasn't your consent to any assignment of the lease a requirement before the lease could be assigned? So why would anyone think that the new owners were now your tenants?
Well, first of all, that was not raised to the court below.
But that's inside your agreement with the actual tenant, right?
Yes, but because the...
And that's part of the record, is it not?
Part of the record, but
Summary judgment
if you agree that the lease is unambiguous, you cannot resort to looking at the lease for purposes of determining the meaning of the purchase
Even if we
agreement.
agreed with you that the lease is unambiguous, there's still the plain language of the lease that we're going to look at, and it does not reference any kinds of commercial property, any kind of tenancy, anything that you might think would be there, any in reference to the actual commercial property, I guess.
Well, I mean, it does provide for the transfer of contracts used in the business and the
Personal equipment and
contracts used.
personal property contracts, right? Not
No, it provides
leases.
for
Doesn't say anything about leases.
It says personal property and equipment leases and contracts used in the operation of the business.
So none of those say lease, right?
Right, but a lease
Okay,
is a
let me
contract.
ask you one last question.
So you know what, you're going to ask that on rebuttal. We're going to hear from you, sir.
Thank you, Your Honors. Jaime Lathrop for respondents. I felt that the questions regarding...
Let me ask you, page 193 of the record, bottom of the page. At request of buyer, seller also to make an introduction between current building landlord and buyer. That clearly contemplates the buyer coming into the premises and being introduced to the landlord. So isn't that enough to create an issue of fact whether this agreement contemplated the buyer taking over the lease?
I would say no, Your Honor, and for several reasons. One, Mr. Ali testified at his deposition that he was not interested in taking over the lease. Second of all, we can also assume that had he been...
So why is this provision in the agreement?
It was drafted by a non-attorney judge. I don't know why it was in there.
The thing about, let me ask a question. Whether or not this purchase agreement is ambiguous or unambiguous, does that really matter? Because if it's ambiguous, then we have Ali's testimony, which isn't rebutted. There's nothing opposing the fact that he didn't want to take over this commercial lease. And if it's unambiguous, there's no reading of lease or rental property or price about what the rent is inside there, right? So either way...
I would take it a step farther, Judge, and say that in the agreement, there would be at least some representations regarding its condition on the lease being assigned, or that there would be something regarding the outstanding guarantee. But there's literally
Let me ask
nothing.
you, I was going to ask your opponent, but I'll ask you instead. Did the new owner ever occupy that space even for 5 minutes?
Not at all, Judge. And you may see also in the brief that we referred that the only transaction that took place was simply transferring a server and a passcode, and this is just...
And there was no discussions with the owner about, can we get approval to take over the lease? Nothing like that happened, right?
I mean, I can say, Judge, in my experience as being an attorney representing leases, I mean, I have seen people purchase, leases that for less than 5 years terms for hundreds of thousands of dollars. But in this particular deal with these sophisticated buyers, no, Mr. Ali was not purchasing a business with less than 5 years with no consent or no guarantee that there was going to be a continuation of the lease.
Thank you.
Thank you.
And I think Justice Garpolo had a question.
I asked it of that counsel.
Oh, okay, all right.
Okay, I just want to raise a few points. As you mentioned, paragraph 12B references making an introduction to plaintiff. I mean, there would be no reason in the purchase agreement to refer to plaintiff let alone to provide an opportunity for an introduction unless the lease was going to be transferred and assumed. I also note that while paragraph 11 of the lease does provide for an assignment, for no assignment without consent of the plaintiff, there would be no reason to seek plaintiff's consent to the assignment prior to the execution of the purchase agreement, nor any reason why consent could not be sought after its execution and before the closing. I also note that
You're saying that someone would, knowing that they needed to get approval from the landlord to assume the lease, would enter into a purchase agreement without having that approval first?
You can answer that. Your time is up, but that'll be the
Oh,
last
okay.
question.
I'm sorry, can you repeat the question?
It's all right.
Okay, all right.
All right, thank you.
Thank you.
Thank you for your substantial assistance in the swift administration of justice.